I want to back up a little bit and talk about Oregon's public records laws. They were created during the Watergate era to keep government officials and government bodies accountable. Oregon didn't even issue concealed handgun licenses until 16 years later. Back then, the information for those licenses should have been made off limits, and it should be that way today, but it's not. And House Bill 2727 doesn't quite get us there either. Let's remember, these license holders did not ask to be put in the public spotlight, hence the term concealed. They did not ask to have all sorts of personal information about themselves and their family on file at the sheriff's office. But in order to get a CHL, they had to fill out the forms. They did not ask to be required to get police permission to exercise a basic right. They never asked to have to pay a fee so they and their loved ones could feel safe. Now it's no longer a right but a privilege, and they're charged for it. And all that personal information they give to the police is now subject to being a public record. It's not right. These people are not public bodies, they are not public agencies, they are not conducting the people's business. Government records should be about government programs, and not whether a single mom living in a remote area of the state has a CHL to protect herself and her children. Or how about that single mom from Medford trying to protect herself from an abusive ex-husband? As told you earlier, yes, that was the case in Medford that brings us to where we are today. As part of that case, a county judge said it was okay for the local newspaper to have some of the CHL records, and that case is now on appeal. The sheriff in that county, regarding that case, related to that case, Mike Winters, had this to say when we told him the bill was going to be amended. He said, "I request that it remain in the original form or as close to that as possible. Our citizens' right to privacy must be protected." Nearly 105,000 letters were sent statewide, with almost as many returned, and the people spoke clearly. They do not want their information to be public record. Now, what he was talking about was those surveys that sheriffs sent all over the state to CHL holders last fall. In talking to the local NRA representative, he said that he's not happy with the outcome of the bill, not opposed, but not enthusiastically supporting. We asked the Oregon Firearms Federation what they thought about amending the bill to where it is today. We received a letter from them saying, Oregon Firearms is not interested in a bill which will create the illusion of privacy protection without reality. Back to the pay-to-play issue for a minute. Concealed handgun license holders are responsible gun owners. They are the law-abiding citizens in our society. There are 109,000 in Oregon, and the number who get their licenses revoked every year is less than 0.5%, way lower than even the lowest level crime rate for even misdemeanor offenses in Oregon. Not only do these people pay a fee, they have to be over 21, they undergo perhaps the most extensive background checks in the country, including fingerprinting. They also have to take a certified training course. I'm not, and you should not, be worried about these gun owners. I am worried, and you should be worried, about the gun owners who are not following the law, mainly the bad guys out there who are out to do us harm. They don't come into the sheriff's office to get a CHL. Don't have to worry about their personal information being subject to a public records request. They don't come and fill out the forms. They don't bother. This is about public safety. How is any of this information about a private citizen in the public interest? In fact, this information in the wrong hands can do harm, not just to the CHL holder, but to others in the community. Are we declaring open season for burglars looking to score or helping identity thieves hunt their next mark? One of my constituents who testified said, given the economy, disclosing the names of CHL holders provides a list of targets for criminals. These are people who wanted to keep the fact that they own guns not a public issue. I'm sure many of you have gotten one or two emails regarding this bill. I did get one email asking me to put, I did not get one email asking me to put CHL license information in the public records statute. There were, however, a couple of emails that really got to me. Both were from women who did not want to be identified. The first was a victim of a horrible violent crime who was then stalked by her violator. The police could not protect her, so she got a CHL. The other was also attacked by a violent stranger. She testified against the man in court and got a CHL for safety. She said, having my private information made public actually re-violates me and takes away that safety. That information I put on those forms in order to obtain my CHL is detailed, extensive, and highly personal. Let's be clear about what could potentially be released here. Stack of applications from the counties around our state. These are the applications one fills out to obtain a concealed handgun license. Now, according to Legislative Counsel, this concealed handgun license in your wallet is probably not the public record. Oh, no, not the case. The agency would most likely have to release the application for your CHL. Some are up to 6 pages long, and they're full of all kinds of information. Not only your home phone number, your address, and your email address, which I heard mentioned earlier, you could request the public agency not reveal. But there's additional information on here, like what kinds of guns you own, whether you were dishonorably discharged from the military, what controlled substances you are taking, if you have prescriptions for them, were you ever in diversion, and information in some counties about personal references, people outside of you. This bill was amended so much it became, I think, unfortunately, an exercise in politics rather than good policy. And the sad part is we've already heard that the debate over this bill may have a chilling effect on those who were considering obtaining a CHL and packing legally. Now they don't want to run the risk of having their personal information exposed. So they may carry without a CHL. I think this should be concerning. Our constituents deserve a bill that actually does what they asked us to do and not create the illusion that we followed their wishes. I know most of us will end up supporting this bill, but in the end, I don't believe we've really protected the individual.